Good morning, my name's Shona Grundy. I'm going to be chairing this session for this morning, but that will only really involve introducing my esteemed panel members and then throwing it over to them. Each panel member will speak for approximately 10 minutes on their area and I think potentially maybe their paths to the bar. And after that, we'll throw the floor open to questions and answer whatever we can, if we can, of any queries or questions you might have. So, next to me, Professor Anthony Lavers is a Whiten case. Chelvan, is that how I pronounce it?
Nope. No, they even include my name here, so it's Chelvan.
Chelvan, there we go. So that was my first mistake. Is at number 5 Chambers. The number 5 has Birmingham and London, but you're in London.
Birmingham, London, Leicester, and Bristol, with the largest set in the country. So I'm based in London.
And then Kavan, Gunaratna. No. We're doing well this morning.
We were setting her up for a fall.
It's alright, I've got my coffee.
Chelvan and I are Sri Lankan, so we're having a competition for the most complicated names.
I think you win, to be fair.
So I'm Kavan.
There we go. And you are at Enterprise Chambers.
That's right.
And down the end there, my dear favourite friend Anton, who nominated me to chair this session today, is at Goldsmith Chambers, also in London. So without necessarily being a spotlight, start this end and work our way down.
Gosh, okay, there we are, the opening gambit. Good morning, everyone.
Morning.
Thanks.
Interactive, is it?
Yeah, I'm always very interactive. If you know me, I'm very interactive, and I'll pick on you later. My name's Chelvan. As Shona said, I'm at number 5 Chambers here in London. I was called on the 14th of October 1999, so I'm 16 years cool, and Kavan paid me a compliment earlier saying you're showing it well. I think that's a compliment for 41 years of age, but there we are, moisturiser works. I thought, how was I going to speak with you and share my sort of life story? And I'm not going to speak about the 41 years, but I thought I'd speak to you about this week, from today to next Saturday, and sort of things which I'm getting up to. And my roommate Rupert told me the other day that I'm in a bit of a whirlwind, and I am. I'm at one of the most amazingly exciting stages of my life. And I'll tell you why. This afternoon I'll be doing the other session at 2 o'clock, and then this evening I'll be going to the Society of Asian Lawyers Ball, which is the Lancaster, where nearly 500 South Asian lawyers and our allies will be there, parting the night away, because I've been nominated as the Commercial Civil Lawyer of the Year Award. So I find out tonight if I've won that. I don't know who's nominated me, so I don't know anything about the nomination, so I'm very excited. But that follows from the fact that last Sunday, the Independent on Sunday published what they call the Rainbow List of the 101 top influential LGBTI people in the country. And Muggins here, as an openly gay man who works in lesbian and gay asylum and immigration law, came in at number 43. So I'm supposedly, according to the Independent on Sunday, the 43rd most influential LGBTI person in the country. And the reason why I tell you number 43 is because at number 55 is Tom Daley. So my byline all this week is I was 43, Tom Daley's 55, and I came on top of Tom Daley. But anyway, I won't say anything more about that. The great thing, and Lance Black, his fiancée, is 41, so maybe there's I have a chance there, but I am happily married. To be in such a list like that with 2 other lawyers, including one member of the bar, Jonathan Cooper, at number 54, and Daniel Winterfield, it is a great sign of how diverse the UK society has got, and especially here in the law, because I'm an openly black gay man with a hearing impairment, and I'm very open about these are the different backgrounds I come from, but I'm here telling you that I'm living my dream. This week involves all sorts of things, including advising in an area of law which I've never done in relation to solicitor negligence with respect to a firm which has come to me as an expert to advise them about what one of their solicitors should have done with respect to a complaint against her. On Monday, I am speaking to 100 psychologists, up to 100 psychologists at Clifford Chance for Freedom for Torture, an organisation which looks at specialist counselling for victims of torture, in relation to a model I created in 2011 called the DISH model, which helps asylum seekers, decision makers in governments around the world ascertain whether a person is a gay asylum seeker. And that model is endorsed by UNHCR and applied by governments around the world. So as a barrister, I don't just do litigation, I'm also involved in policy work and travelling around the world in relation to the area of work I do. So for example, on Tuesday, whilst I got a tribunal hearing in the first year tribunal, and I'm a legal aid lawyer, 80% of my practice is legally aided. I was awarded the 2014 Legal Aid Barrister of the Year Award for my work with lesbian and gay asylum seekers. And I'm very much committed to legal aid work from the first year tribunal right up to the Supreme Court. So on Tuesday, I'm representing 2 asylum seekers, and the government is paying me the big, wonderful brief fee of £322 to save the lives of 2 asylum seekers on Tuesday morning. Yeah, that's how much human life is worth under the legal aid. But I'm committed to do that sort of work because my clients deserve the best representation they can get. Tuesday evening I'm flying to Dublin because I'm giving a masterclass in Dublin on Wednesday to up to 100 lawyers and NGOs in relation to the work I do on LGBT asylum. Because I have to fly back on Wednesday night and not go for the after party, because they've got a party there, and the Irish know how to party, as we all know. Because on Thursday morning I'm in the Court of Appeal on a permission application in relation to a gay man from Albania, where I'm trying to say to the Court of Appeal that he should be having a hearing before the Court of Appeal next year in relation to his claim. And then on Friday morning, I'm in the upper tribunal for a substantive judicial review regarding a family from Albania who fears the mafia in Albania. And then on Saturday, I'll be sitting at my desk preparing an article for a presentation for a roundtable in Glasgow the following Tuesday. So that's why I'm telling you I'm living my dream. I'm not just doing litigation, I'm also representing individuals to empower them. And every single one of you who's looking at a career at the bar, or any one of you who's going to an interview, the thing you need to do is identify your USP. How many of you individuals know what a USP stands for? Unique selling point. Identify your unique selling point. So when I was applying for pupillage or scholarships, and I'll give you a brief rundown because my time's nearly up, my USP was to be the mouthpiece for those who know the words but have no voice. Yeah? Arrogant little bastard I am, but that's what I put in my pupillage applications. Hopefully that'll be edited out on YouTube. And the thing is that, you know, I'm a first generation immigrant. I was born in Sri Lanka. I came here when I was 4. Some of you may have seen the I'm an Immigrant campaign, which was in the general election with posters in the underground. Yeah, 40 years old, I became a poster boy. I was a barrister on the I'm an Immigrant poster campaign this year. As I said, I come from various backgrounds. I grew up in Worthing, which is in Sussex. I went to state school, comprehensive school, up to the age of 16. Yes, I got a scholarship at the local public school, but then I went to a non-Oxford University, Southampton, where I got a first in politics and law. And both Anthony and I are Southampton graduates. I'm very proud of it. And then when I applied for pupillage, I got a major scholarship from the Inner Temple because I got a first-class honours degree. And I'm not going to kid you not. You know, I don't believe that I should be sitting here saying, if you get a 2-2, come to the bar. I don't think so. Less than 3% of people who get pupillages have a 2-2. The bar demands intellectual vigour. Yeah? And I want to be part of the bar in 20 years' time. I don't want to be always worrying and watching behind my shoulder if I've got a career. Yeah? It demands academic excellence. Your clients, who are your solicitors and your lay clients, demand academic excellence. Yeah? So I got a scholarship from the Inner Temple Major Scholarship, which helped me pay for my bar school. Because at that time, the £10,000 actually covered the £9,000 for bar school. This is 1998. Got a very competent, applied for pupillage, got pupillage first time round, because I was determined. Yeah? You have to be determined and self-assured. This is not a profession which will allow you to always worry about where you're going to go. You have to be determined. Because I know so many members of my profession of chambers who didn't get first time round and are now having very successful careers at the bar. Yeah. So I'm going to pause there for some time because I'm sure other elements can be discussed later. But you can live your dream, you can be a legal aid barrister, you can change lives, you can empower yourself. Thank you.
Thank you.
Well, I'm afraid my presentation is going to be less inspirational than that. It's stories like that that make me proud to be a member of the bar, actually. I came late to the bar. I was at a state school myself, a grammar school that was turned into a comprehensive. I went to UCL to read law for my undergraduate degree. And then I did a master's at Southampton, as we were saying, sharing a few reminiscences, although I was there rather before Chelvan. I did a master's in planning law, and I taught in the higher education sector for nearly 20 years without being professionally qualified. Wasn't considered very important in the universities, and most of my colleagues weren't professionally qualified either. But I got a sabbatical in the mid-90s when I was at Oxford Brookes. I was professor at Oxford Brookes by then, and a bit like a man in our village when I was growing up who went mad having won the football pools and not knowing what to do with the money. I was a bit like that. I didn't know what to do with my sabbatical. I'd written a few things, and so I thought I could perhaps write a few more. I could do what academics do sometimes, which is go to a university in another country and have an agreeable year. And I took one of the few wise steps that I've taken in my career, perhaps, which was to take out to lunch an old friend of mine from Christchurch, John Cartwright. Some of you may have been taught by him, a very distinguished Oxford academic. And I said, what shall I do? You're somebody whose opinion I respect. And he said, you're not professionally qualified, you should go to the bar, definitely. And he did it in he's a very quiet man, in a tone that brooked no argument. Here was somebody with certainty who was telling me what I should do. And I did. I'm very pleased that I joined Lincoln's. That's been a wonderful experience for me. I'm not saying it wouldn't have been a wonderful experience in any of the other inns, but I think I got that call right. I chose it on the grounds that it was the most cosmopolitan. When I worked in Singapore, I lectured at the National University of Singapore for 3 years. Many of the lawyers that I met from Singapore and Malaysia were members of Lincoln's, and I remembered that when it came to be time to choose my inn. I went back to university teaching after I had been called. I did pupillages at Keating Chambers for my first 6. I'm a construction lawyer. More of that in a few moments. And my second 6 I did at St John's in Bristol. Now that was a really good idea too, but I can't take much credit for that either, because John Uff, who was the head of chambers at Keating, said to me, you can do your 2 pupillages with us. Keating normally does 12-month pupillages. Even then, back in the 90s, did 12 months pupillages because of the size of the construction cases, the large cases. That's one of the reasons, I think. But he said, if you take my advice, you're 40 years old, if you take my advice, you will look to get a wider experience of the bar. And so I applied to a provincial set, namely St John's, and they had a record of academic connection, and so perhaps that was enough to impress them, and they offered me the pupillage there, and I got a completely different perspective. I mean, it's almost like 2 different professions, the profession in Essex Street and the profession in the provinces. In Essex Street, let's be honest, work just trots through the door. In Bristol, anyway, I can't speak of the whole provincial bar, but I suspect it's the same. You've got to go out and get it. You have to maintain relationships with local firms, with clients of all kinds. Direct access is a big issue in the provincial bar, in a way that it's not perhaps in some of the smart commercial sets. I would probably have spent the rest of my days teaching and just having had an interlude qualifying as a paper barrister. But I suppose it was partly family considerations, not very well paid, the academic world, and had 2 children and a large mortgage living in Oxfordshire, and I decided that I would see if I could put my professional qualification to use. I'd always done consultancy for city firms in the construction law area. Fishburne's the first firm I worked for, and then Barlow, Light and Gilbert after that. And so White and Case offered me a role as an employed barrister in their construction engineering group 4 days a week. The intention was that I would spend 1 day a week in the university and 4 days a week with them. And I'll talk about my role in a little of the time remaining to me. Completely out of the blue, completely unplanned. As I said, I don't really do planning, or at least not successful planning. My old chambers, Keating, rang me up in the same week that I accepted the contract at White and Case and said, "We think you should spend 1 day a week with us and 4 days a week at the university." And their idea was that I should be a part-time director of research there. And I managed to get White and Case and Keating Chambers to agree about that, and we ran it past the Bar Council to make sure that there wasn't any conflict problem. I have to keep away from 1 or 2 matters where chambers are instructed by White and Case, but usually the American firms don't use the self-employed bar for counsel. They use them for arbitrator purposes, of which more in a moment. So it's worked okay for 14 years. My role at White and Case as counsel is a very interesting one, quite eclectic in some respects. I do in-house advices, and I do some training, and I do research for other fee earners, and I do work with business development. So when we're preparing pitches and when we're preparing articles and conference papers, I have some of the technical input to that. It means a lot of travel. I travel quite frequently. We've got offices throughout the world, and I've been to many of them. I've worked in about 15 countries or something of that sort in the time that I've been there. I've been asked to speak today to you not just about construction, although I'd like to say a word or two about that before I close and hand on, but also about employment. It was never a serious prospect for me to go to the self-employed bar. Well, perhaps Chelvan wants to say if I'd shown enough determination that I could have achieved anything, but living in rural Oxfordshire, wife, 2 small children, large mortgage, and seeing how the clerks treated how the clerks treated the baby juniors, it wasn't going to work really. So employed practice gave me an option which I wouldn't otherwise have had, and I'm very grateful for that. You've got security. Putting it bluntly, the salary comes in at the end of each month, irrespective of how well you've performed. I mean, I can tell you there is quite a lot of pressure on you to perform, but your income is not dependent upon that. Your continuation with the firm might be, I suppose. Unlike the self-employed bar, well, self-evidently you eat what you kill. You know. And there is a career structure. I went from being professional support lawyer was my original title to being counsel, and there's no reason why employed barristers today shouldn't become partners. A number of them have in our firm and in other city firms. So the opportunities are there for structured progression in a way that you won't find, apart from silkdom, in the self-employed bar. I think working for a large organisation has its benefits. It has its disbenefits too, which I'm going to allude to in closing. Working for a large organisation, you are supported. You can reach for a professional support lawyer. You can reach for a secretary. There is backup. Things happen which you don't have to do. Whereas on a Friday, when I go to Keating Chambers, which is well funded and economically quite strong, but it's clear that even the more senior members of chambers there have to fend for themselves a good deal. They just don't have the backup. On the downside, working in a large organisation, you are a cog, and there are people above you who, to some extent, tell you what to do. Let you be ever so senior. Whereas at the self-employed bar, as I see on a Friday, even the most junior of junior tenants has a good degree of freedom, and they can give themselves time off if that will still enable them to pay the mortgage at the end of the month. They can actually refuse work, which we certainly don't have the luxury of doing. And the sky is the limit as far as your commercial and professional aspirations are concerned. Whereas in employment, I would say there are limits. Construction, I'd like to say a word by way of a plug for construction. It has a reputation of being dry in some respects, and also people are scared of committing themselves to construction because they think it's restricting, that they're never going to get out of it. I can say that it's a very interesting subject. If you like contract and tort, there's a lot of both in construction law. It's applied contract and tort to a large extent, and there's plenty of it. In good times, there's transactional work, drafting, negotiating, front-end work, and in less good times, lots and lots of arbitration. One of the changes that I've seen in my professional lifetime is the internationalisation of the construction bar, in London above all. When I went to Keating in '97, a handful of the most senior silks did arbitrations, just as arbitrators. Today, every single silk, there are 27 at Keating now, I think, does international work, every single one, and lots of juniors do advocacy in international arbitration. There's advocacy work available which is hard to find in the court system today. So it's quite an exciting story, the growth of construction bar, and I feel very lucky to have been a small part of it.
Thank you. Well, good morning. I think that potentially with Anton, I'm not quite sure, but I think I may be the youngest and most junior barrister on this panel. But then I hope that that has a degree of benefit for you, because I remember very clearly the process that you are all going through now, and the sheer terror that it installed. But one thing I would pick up is that the theme that drove me right the way through was a complete and total determination to be a barrister. And that's hard because it took me 10 years to get to the bar, and I'll tell you where I pissed around before coming here in a minute. But in those 10 years, I was determined that I was going to be a barrister. It was the thing that was always in the back of my mind, and not being one wasn't an option. Now that's hard because the odds are so stacked against you, and when and if it doesn't work out, it can be a difficult matter to come to grips with. But that's where, you know, experiences like Anthony's really do come into their own, because we do not live in a world now where the independent bar is the be-all and end-all of being a successful advocate lawyer. And so, whilst I say I wasn't going to be anything else, please don't take that life is over if a pupillage doesn't come your way. So, where am I? I'm at 3 Temple Gardens. John Coffey QC's chambers. We are entirely crime, and I only defend, and I'd say 99% of my work is legal aid. So at the age of 32, I still live at home. Because the chances of me making a decent living, especially on legal aid at the moment, are not great. I think I would be neglecting my duties to you today if I was to suggest that there is a very large pot at the end of the rainbow at the criminal bar. But I'm sure you've all been told this, and I'm sure you've probably all been told, don't go anywhere near the criminal bar. You'll be eating bread and soup for the rest of your life. Well, bollocks to that, quite frankly, because I was told exactly the same, and I'm still going, and I will make a living out of it, because you do. The thing about the criminal bar, as far as I'm concerned, no disrespect to my fellow panel members, is it is the most fun area of law ever. It's brilliant. And it's the people involved, the characters in the system, no one day is the same. It's a complete roller coaster, and it's so much better than reality television. Jeremy Kyle has got nothing on some of the clients that I have. I secured a pupillage in 2010 and did a 12-month pupillage, and was very lucky to be taken on in the same chambers in 2011. So I've been going now for 4 years almost, which is a little scary. My background, however, is completely different. I was at Durham University, and very, very lucky there to be taught by some fantastic international lawyers, and decided at the ripe old age of 22 I was going to become an international criminal defence lawyer. And so I undertook a research master's, which was going to be my PhD, and then I decided that was too much like hard work. So instead of doing 100,000 words, I did 66,000 words, which obviously there was a great difference there. So I did a research master's on the crime of aggression in international law, which was a very hot topic then. And I was fortunate enough, because it was such a new topic, that the Foreign Office was doing the interplenary panel sessions in Washington and advising in relation to how this offence, if it is to be an offence, is to be constructed in international law. And I basically just stood outside the Foreign Office, kicked on as many doors as possible, and got my way in. And that then led to, ultimately, I came to London after I'd finished that and did the bar exams, but it was never my intention to go straight to the bar, because I had found a way in to one of the defence teams before the Special Court of Sierra Leone. And whilst doing the bar exams, I was working for them, and then went out to Sierra Leone for the final part of the case that we were on, Maurice Callon. And whilst out there, got horribly drunk in a bar and met these two fantastic Dutch lawyers who are mad as a box of frogs, but absolutely the best lawyers I've ever had the pleasure of working with. And they had been given a case, or they'd just been instructed to represent a gentleman by the name of Nun Chia, who none of you will know that name, but some of you may know the name Pol Pot. And Nun Chia happened to be Pol Pot's right-hand man. In fact, actually, it now transpires he was probably the architect of Southeast Asian communism, but that's a minor point. And he was being charged with genocide, war crimes and crimes against humanity in Cambodia in relation to the Khmer Rouge regime of 75 to 79. And they said to me, do you fancy going out there, being our case lawyer? I was like, so with the age-old, it'll be good on my CV, mum, can I have some money? I went to Cambodia, and I was out there for just over a year, working on this case. I'm definitely going to hell, because I spent my first 2 months sat in a room with Nun Chia with a French and a Khmer interpreter, because he decided which one he wanted to speak. Most days, most hours, it would switch. Taking his life story, because nobody knew what his life story was, and obviously we needed to fit that into this very intense period of Southeast Asian history. So at the end of my time with him, at that 2 months, he gave me a pair of his glasses, which is his very famous attire. He never goes anywhere without them. And I now have Nunchia's sunglasses in my bedroom. So yeah, as I said, I'm going to hell. But then I came back. I came back to Europe because I tried to get a pupillage and was fortunate enough to get one. And then in the intervening year, was working for a little bit at the Yugoslavia Tribunal on the Croatian case with Jadranko Perlic, and at Peters and Peters, in fact, which is there. So it's a bit like coming back to work this morning, which is a solicitor's firm doing white collar crime and civil, and I was just paralegaling with them, but it was different but really fun. And then I started my pupillage and got involved with a charity called Just for Kids Law, which operates now out of 3 places, principally Hodge, Jones and Allen, but back then was literally a room in a basement of Lawrence & Co solicitors on the Harrow Road, but run by some of the most dedicated lawyers. Shawneen Lamb, who runs it, is just fairly amazing, and Ika Stevenson, who is a solicitor alongside her. I'm very fortunate to class as one of my best friends. So, having lied to every chambers that interviewed me on the basis that no, I was not going back to international law, and I was committed to the UK bar, which was not my plan, I began my pupillage and ended up specialising through my work with Just for Kids, specialising in representing kids. And that's pretty much all I do now. And the international law is nowhere to be seen. But I spend my life representing mostly young men between the ages of 12 and 16, 17. There's a few girls in there. And in London, it means I do a lot of gang crime. It's horrendous and phenomenal in the same breath, because it's quite scary. There's a generation of kids out there who are so disengaged and disillusioned and abandoned that my bleeding liberal left heart just takes them in. But there are some phenomenal kids out there, and when you actually pay some attention to them and support them in sometimes the most difficult periods of their lives so far, the reward is phenomenal. Sadly, there's not many of them that succeed. I had one girl who I represented during a period in her time where she was in foster care, and she was really angry. That was her thing, anger. And in foster care, you've obviously got to follow the rules. And she wasn't in a family; she was in supported accommodation. And she used to kick the shit out of things. And she would routinely then get obviously prosecuted for violent offences. But when I spent some time with her and with Just for Kids, we got to the stage where we realised that actually she was a phenomenal singer. And we managed to secure some free time in a studio for her. She was noticed, and she has now, because I don't know if any of you were aware or not, but it was the Mercury Music Awards. She is now coming up the ranks quite fast, really, in as an up-and-coming singer, and she wasn't performing at the awards, but she was there, and she has completely turned her life around. And I'd like to think that in some small way there was some stability in what I did that helped her through that. There's no money in it. that's the reality. If you want to go and earn your billions, don't do crime. But if you want to have a job which arms you with an array of stories that will gross out any dinner party you go to and give you some pretty heartwarming moments, it's honestly the best job in the world, and I love it. And I've gone over my time, so I'll be quiet now. Thank you.
Good morning, everyone. My name is Kavan Gunaratna. I am a barrister in practice at Enterprise Chambers in London, and that's a set that specialises in commercial chancery practice. What I want to do before I launch into the rest of my talk is stop there and ask a little bit about you so I can find out what I need to tell you. So, can I trouble you to put your hands up if you are currently studying at university? Okay. Can you put your hands down? Put your hands up if you're currently studying law at university. And hands down. And hands up if you're a non-law student. Thank you. And then finally, hands up if you're doing something more interesting with your life at the moment. Yeah, well done, the one person. I should say, first of all, my confession is I loved my law degree, and I'm not going to let any of you spread that outside the room, but that's really important for anyone who wants to practice in the area that I do, commercial chancery work, because we use our law every single day and apply it to our clients' cases. And my real passion in my job is doing just that. It's getting the best result for my client, whoever or whatever that client is, whatever the difficulty they're facing, using the law and thinking creatively with the law to get me there. So, as I said, my barrister's chambers is a commercial chancery chambers. Now, what on earth does that mean? Despite the fact that 1,200 practicing barristers come under that banner, chancery practitioners, and that's probably about 8 or 10% of those barristers in independent practice of the bar, we still use a term that lots of normal people in the world won't readily understand. So I thought I'd try and explain what chancery means in the simplest way that I can. And I was trying to answer my question this morning, and I realised there are 3 ways that you can answer it. You can answer it by looking at how the courts are structured in this country and the tag that our court system uses. You can look at it by asking what areas of your law degree, if you're doing a law degree at the moment, or your GDL, if you're about to do your GDL, would be used if you became a chancery practitioner. And you can answer it, I think, thirdly, by looking at what the sort of core principles that unite or underlie all of those areas are under the chancery banner. So here's my attempt at those 3 answers. First of all, how the courts are set up. This is something I only really learned when I got into practice, but the courts in England and Wales comprise obviously the county court and the High Court as the 2 principal starting courts, putting aside tribunals for the moment, then the Court of Appeal and now the Supreme Court. And in the High Court, as well as the County Court, which is where a lot of big and complex and important cases are started, its work, the judge's work, is divided into 3 different areas, 3 main different areas. You might have heard of, obviously, the work that happens in criminal work and under the banner of the Queen's Bench Division. So judges sit in the Queen's Bench Division, they handle common law work, which I'll leave others to explain, and criminal work and certain other areas. Judges sit in the Family Division and handle, there we go, an easy to understand phrase, family law disputes. And then judges sit in the Chancery Division, and they do the work I'm about to tell you about. And that work, if you ask a judge, will comprise a whole range of areas. One of the things I love about chancery practice is it is pretty varied. So I've got a list because it's as I say, pretty varied, of some of the tag areas that judges would use to describe the work they do. And here goes: banking, charities, civil fraud, commercial litigation, company, consumer credit, court of protection, financial services and regulation, insolvency, intellectual property, landlord and tenant, land and real property, media, entertainment, partnership, pensions, probate, administration of estates, revenue, tax, trusts and settlement. You can see why I've got a list to write it down. So first of all, it's pretty varied, but also it occurred to me that, having told you about that, a lot of those areas are, again, the areas that practitioners use. I mean, what is banking, what does regulatory work of that nature, what does court of protection actually mean? Because they don't translate to legal subjects. So let me give you my second way of answering the question, which is to talk about the legal subject I studied when I did my law degree. The subjects on my degree that I use, and that you've got to really like, either when you're studying them or in practice, are about 4 or 5 main ones. Contract law. You've got to use and like and get contract law, because a lot of what we do is based on agreements. Secondly, equity and trusts. I know different unis and institutions call it all sorts of different things, but that's one of the core areas in our practice branch. Thirdly, company law or insolvency law. Typically, those are the kind of subjects you might only study on a master's degree or in your third year options, or when you're doing the BPTC, you get options to pick up further substantive legal courses. Those are worth thinking about. And then, fourthly, in the main, property law of different kinds. Now, property law is, of course, and includes land law. I didn't actually, again, confession, like land law when I studied at uni. But actually, I realised that's partly because I just didn't get it. Once I rented my first flat with my girlfriend, and then grew up a bit more and managed to move out from my parents' house and buy a property, I got it a lot more, and I got into it a lot more, and it's one of the areas I actually really enjoy now. So those are the subjects on your law degree or GDL that I think hopefully will ring with the kind of areas we practice in. The third way I was answering it, or trying to answer my own question, was what unites all of these areas? What unites them in Chancery practice? Well, in a dumbed down answer, it's this. It's that Chancery practice has at its core the idea that people who have responsibility and legal rights should be made to exercise those legal rights in a proper way that doesn't involve them doing something they're strictly allowed to do, but would be contrary to someone's good conscience. If it would give you a guilty conscience to use the rights that you've been given in a way that, technically speaking, you're allowed to do, but morally or in a just way just doesn't feel okay, that's where the areas that I practice in intervene and say, no, we're going to stop the defendant, the person with the power, from doing that, because that would just be wrong, and that would be wrong for the victims of whatever's happening. So let me give you just a few illustrations of that. I was scribbling down earlier. The people who have those powers or responsibilities might, for instance, be the directors of a company, because in any company, the directors are the ones who are making the decisions, who have control of the company's property, and the shareholders are sort of in the wings usually, and the directors have a responsibility owed to those shareholders, and sometimes to the creditors of the company, if the company's in financial difficulty, to do the right thing with their powers. It might alternatively be the trustees of a charity. We've seen lots of charities in the headlines recently. I don't want to name any in particular, but you'll see some of them get into trouble because of alleged abuses of their positions as the trustees, the people responsible for looking after the charity's assets, and rather than spending the money to look after the purposes of the charity, they've been doing it in all sorts of either irresponsible or incorrect, unfair ways. It could be, instead, the person in question could be someone who's responsible for looking after the affairs of a vulnerable person. That could be an elderly person who doesn't have mental capacity, because they've got dementia, or might have a very low IQ, might be someone of any age who has a very low IQ or a mental impairment. And the person responsible is meant to look after that individual. Could also be, I'll give you one final example, someone who's responsible for looking after the affairs of a dead person, because the executors of a will, the administrators who are appointed to look after the assets of someone who's dead, will have the control of all those assets and properties. They're meant to distribute them according to the will of someone who's dead, but the person who's dead is no longer around to make sure they do their job properly. So if something goes wrong, if that executor, that trustee, that director, that legal owner of a property is another classic example, is trying to do something that would be within their legal powers but just feels wrong, that's where the principles that I use in my daily job come into play. Now, a few final things that I thought I'd tell you about. Clients, our clients, my lay clients, can be a whole variety of lay clients. So we have, each day of my week, it differs. My client could be an individual who's in one of those categories I mentioned, so it could be a company director, it could be a trustee of a charity, that sort of thing. It could be the victim of an abuse of one of those relationships, so the elderly person or the beneficiaries under a will or trust. There could be not just individuals but companies, multinational corporations in fact, that have businesses overseas, because a lot of our work, I've explained the traditional context, is used, all those principles are used on a big commercial scale to run things like pensions and structured investments and products in the financial markets as well. So it can be a client who's got global reach. Could be also government. So we work for sectors of government who own property or are responsible for assets and making various decisions. It could be local government as well. And as I say, they can be based here or overseas. Three more things I thought I'd tell you. The kind of skills you need if you're thinking about this area, some of the pros and cons about the job, and a couple of closing points. So skills, you need to be intellectually rigorous. Make no bones about it. If you apply to a commercial chancery chambers, they will be looking to you to have at least a good 2-1 in your degree. And when I say a good 2-1, the sort of subject areas that I mentioned before that are really important, you should be pushing as your best subject areas. You should be getting the highest marks you can achieve in those subject areas. If a first is within your grasp, great, go for it. If it's not, still make sure you're pinpointing your applications, the strengths in each of those core subjects. Another skill, you've got to like working, as I said, with the law and be creative in your thinking with the law. One of the things I'm proud of that I've had the opportunity to do in my few years at the bar is develop the law, or work on cases where we've developed the law. We've got a few, just in my few years of practice, reported decisions that have changed how the law is interpreted or understood in one of those different areas, because my practice area gives me happily that opportunity. But you've also got to talk about a little bit of the flip side. You've got to be prepared to take a little bit of a hit in terms of the court work. Shona's area of practice, for instance, criminal law, you will be in court, if not every day, then virtually every day, if not once a day, then sometimes on multiple occasions in a day, sometimes in different courts somehow on the same day.
Clerks don't know geography.
Yeah, and judges don't have much sympathy for that, sadly. In my practice area, when I started at the bar, I was in court every day, but now I'm a few years in, that's maybe a couple of times a week. If I'm working on a really big case, I might be working on that in my chambers, preparing, doing all the preparation, and we're going to go to court in several weeks' time, or even sometimes several months' time, after a huge amount of preparation, and that court case might last several months, might last several weeks or several days. So there's a bit of a mix with that, and sometimes our area involves more preparation, paperwork, and that stuff to balance up with the court work. Merging into the pros and cons before I run out of time. Like I say, if you like your law and intellectual rigour in that sense, then it's terrific. There's good stability, luckily, in our area of the bar. I hope that all areas of bar are vital to just having a society that works. You can hear from my colleagues on the panel how important all these different fields are. I personally don't do much work that's legally aided. Some of my colleagues at the Chancery Bar do, but a lot of our work comes from privately funded clients, and that means that we're fortunate that there's a lot of stability in terms of payment and in terms of the workflow, because when the government is ignoring the importance of access to justice by cutting down legal aid, that affects us all as individuals, but it affects actually my practice area less in some ways than it does other parts of the bar. There's a good balance in terms of earnings and stability in our area of the bar because of the reasons I've just mentioned and who the clients are. What I want to do finally is give you some tips on my couple of best things to do if you're interested in following up on this area. One is to study hard. There is no doubt that, as Chelvan says, you've got to have a USP, as Shona says, you've got to push yourself and be absolutely determined if you want to come to the bar. But I'll also make no bones about it. Chambers in Chancery and commercial practice will look at your CV and they'll look at your law degree or your degree results, even if you did a non-law degree. They'll look at how hard you worked when you were studying, because you've got to have that real drive and intellectual rigour and love of your studies as well. So push it in your law degrees if you're still studying on that. Secondly, get to know the legal market, and that's kind of obvious, but I have to say, well done to everyone. You're doing absolutely the right thing. It's such a competitive world that we're in coming to the bar. You need to be here at events like this, pupillage fairs. You need to go and meet barristers' chambers. Don't be shy when you go and meet the barristers later today. Go and talk to them. Make them remember you and your face when you come for interview at their chambers. Learn everything that you can about them and go and apply for mini pupillages in good time before you apply for pupillage. I think I've probably overrun my time slot, so I just want to say best of luck to you all with it. It is the absolute best career, I think, for all of us that we could think of. That's why we're here of our own free motion on a Saturday morning. So we hope you can come and join us in a year or two. Thank you very much.
Last but not least,
in the style of T.S. Eliot, not with a bang but with a whimper. My name's Anton van Dellen. I'm a barrister in practice at Goldsmith Chambers, which is probably 50 yards that way. I practice in mixed civil, and my story or my area of practice is not as glamorous as everyone else sitting at this table. You've heard how intellectually rigorous you need to be in other areas of law. You've heard how exciting Shona's work is, and Shona works in this forgotten niche in the criminal justice system, the youth court, that's underfunded and just completely forgotten by the whole criminal justice system. You've heard about construction law and employed practice. And yet, very few of you will be thinking, I am passionate about getting my client their £1,000 for whiplash, or I'm passionate about this slip and trip at Tesco's. And yet, when you walk out of this room, I will have convinced every single one of you that you want to be doing mixed civil law. And I'll tell you why now. There are 3 reasons why you're going to walk out thinking, I'm going to apply to do mixed civil law. The first is about getting a pupillage. The second is about how comfortable you're going to be. And the third is about the variety of practice. Be under no illusions, there is a massive cull getting a pupillage. We have 425 applications. Last year we had 4 positions to fill. It's a huge cull. Your competitors are passionate about human rights, immigration, criminal justice, Chancery, commercial. There are not a lot of competitors that are passionate about whiplash or passionate about slips and trips. So if you are savvy, you realize, do I want to be competing with somebody who's worked for on death row, or like Shona working for Pol Pot's right-hand man? I'm not going to be able to compete with them. I've got a far better chance of getting a pupillage applying for a mixed civil set. Unless you have a top first from a good university, you are not going to sail into Fountain Court, Enterprise. All of these other commercial Chancery sets have a strong dose of reality. Your competition is going to be much less fierce applying for a mixed civil practice. The second reason is that you are going to be comfortable. Take heed of Shona's warning of living at home. You cannot survive on going to magistrate's court for £43 and not having your travel paid. You will starve. It is not a coincidence that people are flooding out of the family bar because they've cut family legal aid. You cannot afford to pay your chamber's dues being paid tens of pounds a day. You will be comfortable doing mixed civil work. You are not going to make stellar amounts of money like they do at the construction bar and at the Chancery bar, but you will be very comfortable, and after 4 or 5 years of practice, there's no reason why you cannot put down a deposit on a small flat in London. You're not going to be living in Belgravia, but you will be able to afford to buy somewhere. And the third reason why you're going to walk out thinking I'm going to do mixed civil is because you're actually going to do interesting work. It's not going to be passionate work to deal with asylum seekers. It's not going to be changing people's lives and turning them around, but it's going to be interesting work. And I'm going to give you an example of the 5 areas of law that I've touched on in my last week, just to give you an idea that it's not just whiplash and slips and trips in Tesco's. The first case I was dealing with is a cash seizure case. My client had stuffed 14,000 euros into his underwear and had been caught at Dover. And I persuaded the Crown Court at Canterbury that that's not concealment, it's completely natural to put 14,000 euros into your underwear when you're travelling abroad. And you're saying, but why was I at the Crown Court? I'm a civil barrister. Cash seizure is civil procedure, but in criminal courts. The case stated from that went up to the Divisional Court at the Royal Courts of Justice, and Sir Brian Leveson was deciding on, in, funny enough, another Sri Lankan name, Parampanathan, the costs recovery in cash seizure cases. The second area I'm working on is professional disciplinary. So representing a client who's facing proceedings before his professional regulator. He's had a conviction for domestic violence, and his professional regulator is now taking proceedings against him. Is it important for him? Yes. He's not going to have a living if his regulator strikes him off. Is he in big trouble? Hell yes. He's been convicted of seriously assaulting his spouse. It's really important we get this right. The third case is an inquest. My client wife was bedbound with multiple sclerosis. The GP didn't come out to see her. and a few hours later she died. And he said he wants to have an inquest to hear the reason why the GP didn't come out to see her. And the coroner has said it's a natural death. He's not holding an inquest. And last night, I got an email from my client to say he's issued the judicial review again in the High Court, the Royal Courts of Justice, to judicially review the coroner and to challenge the coroner's decision. Is it about a large sum of money? No, it's not. Is my client wealthy? No. Am I going to make a lot of money from this case? No. But it's an interesting case. And for him, it's a very important case. It's the last thing he can do in his wife's memory is find out why this doctor didn't come out and see her. The next case is an action against the immigration authorities. Effectively, our chambers does a lot of work against the actions against the police. Our head of chambers, Tony Metzer, is in a big court case action against the police in Cardiff at the moment. My client had an appeal running, and for whatever reason, the Home Office said, we're not letting you out, and we're running a claim of false imprisonment against the Home Office. Is my client going to get a lot of money? Probably not. A few £1,000s. Does he feel strongly about it? Yes, you bet your bottom dollar. He feels passionately about it. Does this sound boring stuff? Does this sound whiplash stuff? No, it's not turning somebody's life around like Shona, but it's still interesting work. It's got a wide variety of stuff through there. You can probably spot there's a thread of human rights running through a lot of what I do. So it's not LGBTI, it's not asylum work, but there's still human rights concepts, Article 1, Protocol 1 with cash seizure, right to life with the inquest work. You've heard about direct access. We do a lot of direct access work. About a third of our chamber's income comes from direct access. The junior end of the bar, find out about direct access. That's where your clients are going to come from. That's where your income stream is going to come from. We invariably ask applicants to our chambers, what do you know about direct access? Very few of them can tell us anything about it. It's all find out about it. And finally, I came to the bar because I like advocacy. I like being in court. I like representing my clients. I like convincing a tribunal or a judge that my client's €14,000 and him having had a conviction for supplying drugs into prison. Of course this isn't the proceeds of his drug laundering. This is just a loan from Poland that he just happened to have carrying around in his underwear. So I hope I've given you 3 very good reasons to consider mixed civil work and not to poo-poo it as ambulance chasing a load of nonsense. The first is the competition. It is much easier to get a pupillage. We don't want somebody only from Oxbridge. We don't want somebody only with a first. We want somebody who's interested in representing clients. The second reason is you're going to actually have somewhere to live and eat, which is quite nice, actually, in 10 years' time. And the third reason is the work is interesting. There's a wide variety of work, and you will find interesting clients, interesting people to work with. So I hope when you walk out of that door, you seriously think about mixed civil as an area of law that you want to practice in. Thank you.
Well, I was going to open the floor to questions, but now that Anton has convinced you all that mixed civil is the only thing you want to do, you may as well just direct all your questions down that end of the table. Just as you can see, this is being recorded. Please don't think it's weird, but myself and my panel members, we're just going to repeat the question once you've asked it so that it's captured for the footage. But the floor is yours. Okay, we'll go down the back.
I have 2 questions, if that's okay.
Okay.
One is for Chelvan, and you mentioned that about 80% of your work is immigration. I've spoken to quite a few immigration barristers, and they've all kind of repeated what Shona has said about making a living and the lack thereof in terms of prospects. And I was just wondering if the other 20% of your work is kind of what you do to help with that level of support, or and if so, kind of how you manage that? And then my other question was for Anthony.
That's absolutely fine. I will come back to you, but let's deal with each question.
Your name is? Elizabeth. Okay, so Elizabeth's question is that I said that 80% of my practice is immigration legal aid. When I say the rest of my practice, about another 15 to 18% is also immigration and asylum.
Okay.
But as Anton was saying, there's something called direct access, or there's privately paid cases. And I don't want to even start about what's called age debt. Do you know what age debt is? The money we're owed by solicitors. And my age debt's in 6 figures. That's the money. The majority of that money is the money the government owes me through legal aid. And the only reason why I'm able to pay my mortgage and well, I say pay my bills. No, I'm 41 years old and I have difficulty paying my bills. I'll be honest about that. I was very lucky that when I was going on the property market, HSBC used to allow you to have 4 times your gross salary as a mortgage. So I didn't need to get a deposit. So luckily, because my husband sold his house, we was starting dating, is that we actually have property. I don't know how anybody in the junior bars gets onto the property ladder now the banks are doing what they do. So the only reason why I'm able to stay afloat, and I say stay afloat in the most flimsy, is because everybody at the legal aid bar has difficulty paying their bills, unless they're very good with money. Most barristers aren't very good with money. It is that I have direct access work, which pays up front, which I've started, and because I have a niche, people do go to me in relation to that, and then privately funded work. I was speaking to a junior colleague, a junior of mine, in relation to this, who's been at your stage of your careers far more recently than I have, and she said, if you want to go into this area, you're going to have a second string to your bow. You have another area on top of immigration and asylum, or one of the legal aid areas where you can actually gain funding, because at the start of your career you're not going to get the big cases. When I started, and I did pupillage at Dowdy Street and Garden Court, and I started my second six at Garden Court, those were the good old days where you got paid per hour for the work you did. And because myself and my fellow squatter was earning so much, Garden Court actually doubled the percentage from 5 to 10%, because we were earning more than the bottom 25% in the criminal tenancy juniors. But that's all gone. Immigration's completely gone out of legal aid, and it's now only asylum. And as I said, £322. But you can do this area of work if you're passionate to do that. Because if you guys don't come and do this type of work, then what's going to happen to the independent bar? What's going to happen to those most vulnerable people who don't have a voice? I get very angry because of the changes in legal aid, and I am an activist, I am a political busybody, and I go around on various news stations and talking about the damage, because when it comes down to it, when you get a decision wrong in my area, somebody actually dies, or tortured or raped, or that's the end point. So I know Anton's saying it's very difficult to get into these areas, but I did, and I had no money when I came to the bar. I was self-funding. My parents had kicked me out because I came out as gay, but there were people out there who supported me, who believed in me, who enabled me to have doors opened. And there are people like me now who will be committed to opening doors to you as well. So there are the opportunities to do this type of work, and you can. But as I said, definitely don't go for the money. And even when you earn the money, the government takes 5 years to pay you. And especially if you win the case, Treasury solicitors or now the government legal department fight tooth and nail to pay you your fee, and you're taxed on your age debt as well. It's horrific. But would I do anything else? No. Because what I do the work for, and I'll quickly end on this, it's a thank you card. What I love about my work is when I get a thank you card from my client saying thank you for saving my life. And that's priceless. You can't put a price tag on that.
All right, thank you.
Sorry.
No, not at all. I was just saying I never get thank you cards, but there we go. That's right. Either they don't care or they can't write. I know you had another one. Can I come back to you? Is that all right? Because you had a question here.
Yeah, mine was quite simple. I have to really say sorry, because before I came here, I have never heard of your set. I'm so sorry.
That's okay.
I know the other sets more or less a little bit. So did you say your set is called mixed civil set?
Well, Goldsmith is certainly our pupillages are mainly criminal pupillages, and that's where the bulk of the work at the junior end is. But we find even our junior tenants tend to do a bit of work that's associated with crime, so actions against the police, cash seizure, road traffic work, and that work is privately paid. So that I've broken Shona's rule. I haven't repeated the question back. So Goldsmith doesn't only do mixed civil. Our pupils are mainly criminal pupils.
I see, but the set you are trying to tell us here is called mixed civil set. So M-I-X-E-D, civil set.
Well, mixed. So the question was about mixed civil. So mixed civil is just the general area of law. So it's very similar to common law. You heard there's Chancery. Most of what we do is in the Queen's Bench division rather than in the Chancery division. So we're appealing our case stated from our cash seizure up to the divisional court. Our judicial review of the coroner is heard in the administrative court. That's all part of the Queen's Bench division.
I see. So, sorry, one final one.
That's okay.
I'll be done. So, what's your day-to-day life like?
My day-to-day life.
Yeah.
My day-to-day life is varied. It will generally be at a tribunal or a court, usually somewhere within the M25 is my general practice, although I go out to Luton quite a lot and Reading, but generally within the southeast, occasionally up to Birmingham. In the late afternoons, I'll tend to have a consultation with the clients. I'll come back from court and then have a consultation. But again, like everyone else here, we tend to work quite long hours and go back to chambers, have a conference with the clients at 6 o'clock this evening who's had some money seized by the police. So we squeeze in our consultations between our court work and everything else we do.
Thank you very much.
Anton is being very modest here because he's also a tutor at BBB University, which is
So yes, the comment was just about some of the other things we do. There's obviously a lot of activism work, advisory work, and there's potential to do some academic work as well. So a lot of junior tenants also teach as a way to supplement their income and out of general interest as well.
Wow, that's amazing. And also just comment on one of your cases. It's very normal to put money in underwears in China as well.
Well, I'll call you as an expert witness.
All right. So I know you had your second question, so I'll come back to you.
Okay. It was for Anthony, and a question about the employed bar. I know you said you worked for 20 years before coming to the employed bar. Is there scope, aside from the government legal service, is there scope for someone at the junior end bar who doesn't have as much experience to go to the employed bar? And how would you go about doing that?
The question is, in the context of my having come to the employed bar late, would a more junior person with less experience be able to get started in employed practice, if I understood Elizabeth's question? There are lots of opportunities. I can only really speak of construction, but I'm sure that this is true of general commercial as well. It certainly is in our firm. If I look at the associates, as we call them in American firms, they're called assistants in English solicitors' firms, many of them are barristers. And they are sometimes of 1 and 2 years call, and the American law firms have made a practice of waiting like almost like sharks outside the doors of chambers, outside of specialist construction sets, and finding those people who haven't been taken on and snapping them up as they come out in a traumatized state, having not been given a tenancy. And many of them end up as NQs in US firms, newly qualified in US firms. But not all of it's in a kind of negative and reactive way like that. That's a choice that a number of barristers make, increasingly so, I would say. The reasons that I've set out are compelling for some people. The stability and the and the career structure and the relative certainty. I mean, you can still be sent around the world at relatively short notice, but some people would prefer that to being sent to Colchester County Court for a 9 o'clock start tomorrow with no warning. So for all of those reasons, young barristers do choose the employed bar with large law firms and other organisations with large corporations outside of the public sector, which is what you referred to. The answer is an emphatic yes. There are lots of opportunities once you get over the pupillage problem, and there are not many pupillages available in the commercial sector. But once you've got through that hurdle, and I know that's a big when, but once you have, there are lots of opportunities in the employed bar, both public sector and private sector.
Anyone else with some questions? Okay, a hand up down the back there.
You keep saying how important it is to try and get a very good degree, a high 2-1 or a first, especially in the commercial sector. What about the university you come from? Is that really important in the bar?
Sorry, the question is the university important about where you get in the bar, first or a 2-1?
Yeah.
Before I answer that question directly, nobody's talked about postgraduate qualifications. Yeah. When I did pupillage first, nobody in my cohort, and this data in Garden Court, had a master's. Yeah. What then happened in my life is that I got an opportunity to do a master's. I went to the States and it was all funded, and I came back and everybody had a master's. And even with our pupils now, they all have masters or PhDs or whatever. This sort of feeds into what Kavan was saying about the love of learning. So I would really advise you that it is 1 year of your life. There is funding available for you. As I said to you, I had no money. I didn't go to Oxbridge University. My little take on Oxbridge, and I apologise, it's my little black humour thing, is Oxford and Cambridge are number 3 and 4 in the world. I went to number 1, Harvard Law. So that's my little negative thing on Oxford. But no, in my chambers, you go to Legal Cheek. They have these things about the barristers, the chambers lists. And my chamber's number 5. Only 2 out of our 5 most recent tenants had Oxbridge degrees. So I can only talk from my chamber's experience. It doesn't. It really depends how you present yourself, how you sell yourself. We're very generous. We offer a £40,000 stipend. We're the largest set. We have tree huggers like me, and then we have the commercial members of the chambers who earn the gazillions, and I'm the outlier who's dragging everybody down. But the point is that it doesn't really matter. I would say try and go for the first. I'll tell you why. Because 30%, a third of those who get pupillage in the most recent figures have got first. Yeah, and you can do it, but don't just study. I was hearing anecdotally from a law tutor from a university, which I won't name, about somebody who was so worried about getting the first that they weren't doing anything else. They weren't doing the mooting, they weren't doing the advocacy, they weren't doing the societies, they weren't going out there and doing other things. But don't think that you need to do amazing things like Shona. I'll give you another anecdote. Being the shy, retiring wallflower type I am, I'm sometimes dragged onto pupillage committee interviews. And in my old set, I thought, for God's sakes, somebody set a bloody NGO up in South America, all this sort of stuff. And I said, insert expletive. The person would work for, insert expletive, Mother Teresa. And I kid you not, and this is, I have this wonderful relationship with God where he laughs, or she laughs with me, where the first applicant on that last round had worked for the Calcutta Mission. Okay, that's the irony of life. She actually had worked for the Calcutta Mission, but her advocacy was terrible. She flunked the advocacy exercise. So, you have to be an all-rounded person. You have to be the leader, you have to be the teamwork. You have to show the writing skills, but you also have to show the advocacy skills. You have to show your USP. So it doesn't, because, even one of our junior tenants, and I want to be careful because you will be able to identify him if I tell you where he went to, but he went to his undergraduate degree was at one of the universities which has the lowest A-level grades entry requirements in the country. And we're number 5, we're the largest set in the country. We won Chambers of the Year last year, the Lawyer Award and Regional Set at the Chambers UK Awards this year. So, I'm going to sell the brand name, I'm not on the pupil committee, we're cutting edge, yeah? We go to the Supreme Court, we do the European courts, but we have one of our junior tenants who went to one of the universities which has the lowest entry grades, yeah? So, but the thing is to show academic excellence wherever you go. I'm part of the Equality, Diversity, Social Mobility Committee, it's a mouthful, the Bar Council, yeah? The Bar is doing a hell of a lot of work regarding social mobility. And I know One Crown Office Road, go on Twitter, by the way. Twitter's a wonderful way of learning things. I'm on Twitter, @_Chelvan. Because, there are chambers out there, such as One Crown Office Road, which are now doing CV blind interviews. We are determined to change things. And we're doing a lot of work within the Bar Council, outside the Bar Council, in our respective chambers, in our respective inns. I'm part of Inner Temple. We do a lot of work to try and change things because we do believe on getting the best advocate. Yeah, because I remember when I was doing pupillage, there was a guy who's president of the Oxford Union who'd got a 2-2 who didn't get pupillage. Yeah, so don't think just because somebody went to Oxford they get walked in the door. The bar is changing. Things need to change more. But yes, it matters about excellence, not where you went to.
All right. It's always the way when you get a load of barristers and the opportunity to talk. Because we are at 12:30, but I know that there was a hand up down the back and I think one over there as well. So the lady down the back, you had a question as well?
I have 2 questions for you.
Oh.
The first is, are your mini pupillages assessed, and how many do you make available in any given year?
And what was your second question?
That was the second question.
Oh, that was, and how many? I'm not on the pupil. So my first, the question was in relation to my chambers and whether or not the mini pupillage is assessed and how many there are each year. In terms, I'm not on the pupillage committee, but I do know that they are not assessed in terms of there being any entry requirements. It's simply an application to the pupillage secretary, enclosing your covering letter and your CV. We, as is often the way with criminal sets, get a lot of applications for mini pupillages because you really do get an experience of court life. So I think we try and balance them out throughout the year. But we undertake quite a lot of pupillage, mini pupillages. There's often one or two being usually handed off by whoever's been given the mini pupil for the week. So that's, and then in terms of its impact, if you were to apply for a pupillage, there's no formal assessment and it doesn't make any difference whether or not you've done a mini pupillage with us. All it will be is just giving you a practical experience of who we are and what we're about. I'm very fortunate to be in John Coffey's set. I think, quite frankly, they're probably the only chambers at the bar that would have me. But then they are the group as a whole are often quite nuts. But we're very, I'd like to say that we're very down to earth and very human in our approach to life and to crime, and that permeates throughout the way we run our chambers and the fact that the Edgar Wallace is our annex, and we spend a lot of time there. If you want to come to the criminal bar, you need to learn how to drink. Anyway, right, so that not being my advice, there was a oh yeah
So I'm trying to do my EPTC.
yeah.
Do you offer like day pupillages rather than a week?
Yeah, well, so the question is in relation to day pupils. I don't know is the honest answer, but if you write to, I'm not quite sure who our pupillage secretary is at the moment because we're having a little mass vacation of junior tenants. We've lost 8 members of chambers to the SFO or the FCA in the last 18 months, and I know that our pupil secretary has gone as well. So I'm not sure who it is at the moment. If you go on the website, they would write to that whoever is on the website. Then that should be something they can inquire for you. All right. And there was a question over there as well.
Yeah. How important do you think it is to have a clear idea of what practice area you want to go into when you're applying for pupillage?
Who wants to do that?
Can I answer that? So the question is, how important is it when applying for pupillage to show that you've got a clear idea of the practice area that you want to go for? I'm going to answer that from my own understanding, both as an applicant when I was a student applying, and from the other side of the table, because I'm now sitting on recruitment committees and I do interviews. When I decided that I wanted to become a barrister, I didn't know exactly which area of law I wanted to spend the rest of my life in. I had a good idea what I didn't want to do. I could rule things out, but it was harder to put your finger up in the air and say, definitely this for the rest of my life. And that's a perfectly understandable reality. Then I came to apply, and I realised that barristers forget as soon as they get into chambers and start sitting on recruitment committees, they forget sometimes the perspective of normal human beings as students, in that you don't know exactly where you want to practice for the rest of your life necessarily, and we expect you to have a burning passion for the work we do, and that is because we can afford to set the bar really high. Every single area of the bar, when they're looking for new applicants, can afford to say, we don't care about your background, we just want the best. And we also want, under the description of the best, the most determined. And you will need to sell yourself as committed to the area in which we practice. And that goes back to one of my basic tips before, which is before you come to apply, make sure you've done your research, which is why you're here. Make sure you know what the different areas you're thinking of applying to really constitute in practice. This is why you're asking the questions you are, and make sure you understand what the Chambers does, and then preach their story as if that's the only thing you really want to do. I think is the honest truth.
Can I add something to
Yes,
that?
please do.
Could I add something to the question which is about specialism and the need to specialise early? I would endorse exactly what's been said. In the case of specialist sets like Keating, which is 100% construction and engineering, it would be absolutely hopeless not to understand what the specialism is and to convey enthusiasm for it in making the application. I don't do pupillage interviewing or applications, but I do interview legal assistants. We have every year a legal assistant who is an employee, and without exception the appointee is always somebody who hasn't got a pupillage, often very good graduates of leading universities and of the BPTC, but who haven't yet got pupillages. And I'm staggered by how poor the preparation and research has been of some of apparently the best candidates on paper. For example, Keating Chambers produces a standard textbook which is well known throughout the industry, and it's on the website, Keating on Construction Contracts, and a number of applicants in interview don't know that this exists, which they could have found out just by going onto the web page. So doing your homework and then translating some knowledge. You're not expected to be an expert when you're at this stage, but some knowledge and translating that into enthusiasm, in my view, for a specialist set is absolutely essential. It may be that Anton will give a slightly more nuanced response to this, but certainly that's
Completely agree.
certainly that's my view of the construction bar. Anyway.
Yeah. Well, I mean, I think all I would just finally add in terms of that is don't be afraid to take your time to come to the bar. If you're not entirely sure as to where you want to go, it's really hard work, and it is, as you all know, daunting prospect of not necessarily reaching the top of that mountain. And so if you're thinking about an area that you like or want to potentially explore a bit more, go off for a year and do some practical work in it. The difference between academic law and practical law can sometimes be completely vast. and those that have loved it as an academic subject get into the practice of it and want to put pins in their eyes. So, you know, don't be afraid to take your time to explore what your options are and what you like. And I think that sometimes there's quite a rush to get pupillage, but actually sometimes taking a bit of time putting together something that you then obviously, because passion shows. You know, you can be a good actor, but passion shows. And if you've gone and found that in somewhere, you know, doing whatever, that will come across. Well, look, we've gone over time, which I'm going to get told off for. I promised I would keep to the schedule. But thank you very much. Good luck with the rest of the day, and good luck with your applications.